a new penalty phase jury, and the last sentence of it does say, consequently, you will not concern yourself with the question of guilt. So if the court wants to somehow add that in, we could do that, but I do think it is absolutely appropriate to say to the new jurors, the question of guilt has been decided, it is not before you. I don't think that's improper at all, but anyway.
Well, this is not a new panel. They sat through the entire trial. So the court's going to give the jury instructions that were set forth in this matter. Are there any other matters that we need to take care of prior to bringing the jury in? Obviously, the jury would be instructed after closing arguments. So I would simply advise the jury, the usual inquiries I make of them, advise them about the jurors that has been let go and the two alternates, and then we move into closing arguments. Are there any other matters?
The only other thing is, Judge, I had asked yesterday for the instruction to be modified to say that it's necessary that the advisory sentence be unanimous, and the court denied that. Of course, the case law currently says that's not appropriate, but I did follow up with a written proposed instruction, and it's simply the last page of the instruction we agreed to, and that sentence changed, and second to the 4th and 8th Amendments of the United States Constitution to support.
So you're filing this for purposes of record?
Yes, sir.
Okay, all right, thank you. The court has previously ruled on this matter, and I state, I'm assuming you have no other argument on that. All right, thank you.
Can I follow?
Yes, you may. I'm sorry, I'm just being administrative here for just a minute. Let me give you copies of these jury instructions to everybody. Oh, it's over here.
I have not changed sides, Your Honor.
Hang on just a minute, let me make sure I have.
Thank you. No. Thank you, Your Honor.
Mr. Okafor, any matters that have come up since yesterday, sir, that you need to address with the court prior to proceeding? I'm sorry? Okay, do you want to ask your counsel about that first or not? I'm sorry?
Your Honor, my client, I mentioned to Mr. Altman yesterday about the 911 call that was in the guilt phase. We played the part with Amy Scott, but apparently Brianna Campos was on part of that, was never played here, was not provided to us. So he wanted to make sure that it was on the record that that portion of the 911 tape was not played in this case and was not provided to us.
That's incorrect, that it was never provided to the defense. They had.
Well, I don't think she wasn't provided to prevent. She said that it wasn't played to the jury?
It wasn't played to the jury, and it was not provided to us. We took a deposition of Amy Scott, and we were provided the tape, part of the tape that they were using in this case. My client is raising that issue, possibly as some kind of Brady violation. I haven't heard the tape yet, that part of the tape yet. I know she spoke on the tape, and I know because the officer said he saw it on the phone when he testified in this case.
I'm sorry, I'm having trouble understanding what the issue is.
Is there a motion before the court?
Hang on a minute. I'm trying to find that out. What is it that you're asking for?
Well, he just wanted to put on the record that part was not played, and at this point, Your Honor.
Okay, wait, go slow. You're asking to put on the record that part of the 911 tape that was the conversation that Brianna Campos had was not played to the jury?
Yes, sir.
Is that an issue?
Yeah, I told him.
Hang on. Is that an issue?
I didn't hear the question.
Mr. Mr. Mosley simply wants to make sure that it's on the record that the part of the 911 tape that reflected comments made by Brianna Campos was not played to the jury.
That was not played to the jury. There is a CD which the defense has had for probably...
Okay, don't get past that, because that's the only issue right now, and that's what he's asking me.
Well, he mentioned about the defense didn't...
I know, let's get that secondarily.
Okay.
But so that, it was not played. The jury doesn't need to be reminded of that. It was not played.
No, sir, not in this proceeding here, but just the issue he wanted on the record, so.
Okay, all right. Well, I don't think there's any issue on that. Now, was there some issue about non-disclosure? Is that what you were raising?
Yes, counsel said they provided it to us in discovery. I don't have it. I know that we did, I knew there was a 911 tape. I knew Amy Scott had called. We did depots on her, and I suspect, Your Honor, that in that tape, Ms. Campos is going to say what she said here, but in the abundance of caution, my client wanted to put it on the record.
Is there a motion before the court? I don't understand what...
Sounds like...
on the record, but are we doing the motion for something?
We're past the part on the record. The question is are we now into a situation where I need to conduct a Richardson hearing? Is there some discovery violation that we're talking about?
They didn't give us the 911.
Your Honor, that may be...
I can't deal with maybes. There either is or there is not.
I didn't have the tape. I didn't have the tape.
Judge, at this point, I'm not quite sure why this is even being brought up now. May I suggest that we proceed to the closings, let the jury deliberate, and we can, and if the defense wants to file a motion, we can deal with it when it's done. I don't really understand why this is coming up now, why we're delaying this jury's resolution of this case, but we'll be happy to deal with it if a motion is filed at an appropriate time.
Yeah, I can do that. I can file a motion after this proceeding is over.
Okay. All right. Thank you. Any other matters before we bring the jury in? Okay.
Not from the state.
All right. Mr. Okafor, anything else?
No, sir.
Okay. Thank you. Let's go ahead and bring our jury in. Do we have the pads there? I think we do. Oh, do you want the podium back in front of them? Okay. Mr. Mosley, are you going to be doing closing, or Mr. Do you want this podium? Do you want? Tell me what you.
Wherever they are is fine.
Okay. If you want to move, just let us know.
Thank you, Judge.
I'm not going to give the jury copies of the jury instructions until I administer those, so they will not have them during closing.
All right, Virginia.
Please be seated. Good morning. Welcome to all of you. First, let me apologize. I got here so early this morning that I went by the bagel place. It wasn't open yet, so I couldn't get you bagels this morning. I do apologize for that. We have one of our jurors that is missing. She is ill and cannot be here, and that's the reason she's not here today. Because we are missing two jurors, juror number 108 and juror number 110 are now part of the main panel in this matter. I need to ask each of you, has anybody contacted any of you or approached any of you about this case since you left here yesterday? Please raise your hand if they have. I don't see any hands. Has anybody conducted any research, seen anything on the TV, the newspaper, on the internet, or any place else, or spoken with anybody or communicated with anybody through the text messages or Facebook or anything else about any of the issues, any of the parties, any of the attorneys, or any of the witnesses? If they have, please raise your hand. I don't see any hands. And has anybody else seen any of the other jurors conducting any research? You have raised your hand. I don't see any hands. All right. We are going to move into closing arguments. I saw one of you has already picked up one of the shawls. They're there if you need it. It seems to be a little cool this morning. If you need one, just let us know and we'll hand it to you, or you can reach over and grab it. There's some extra pens on there. Paper-wise, is everybody okay with their pads? Does anybody need a new pad to supplement what you have? If you do, please raise your hands. I don't see any hands. All right. Once again, the attorneys are going to be speaking with you. These are the closing arguments. There we had opening statement. This is closing argument. What the attorneys say is not evidence, but it's extremely important to you and will be very helpful to you. They need to know you can understand them. If they show you something, they need to know you can see it. So if you have any trouble hearing them or seeing something, please let them know, and they will make a correction on that. Each side has an equal opportunity to speak with you. The state will go first, followed by the defense. Mr. Ashton?
Okay. Good morning. It's been 3.5 weeks that y'all have given us your careful attention, and we all appreciate it. We know it's been difficult. We've asked a lot of all of you. We're going to ask even more of the 12 of you that deliberate this case, and welcome to our two alternates to the jury in this case. It is a little bit of an unusual circumstance to have those who did not participate in the actual original verdict to participate in the penalty phase, but thank you. That's why we have you. The task that you will perform shortly is a weighty responsibility. The judge will give you a number of instructions about carrying out that responsibility. It is going to be your responsibility to decide what the appropriate punishment is for the murder of Alex Zaldivar. We don't just give jurors that decision and say, well, you guys figure it out. Equal justice under the law requires that jurors here and jurors in Tampa and jurors in the Panhandle and jurors in Miami be guided by the same principles in making this very, very important decision. We don't want jurors to just do this based on emotion or caprice or individual moral senses. It needs to be guided by the law. But as I've told you, most of you, in jury selection, ultimately how you weigh the evidence in this case is left to you, guided by the court. The judge is going to give you an extensive group of instructions. I want to start with one, I think, very important one. The judge will tell you that your recommendation should not be influenced by feelings of prejudice, by racial or ethnic bias, or by sympathy. Your recommendation must be based on the evidence and on the law contained in these instructions. I want to specifically highlight the word sympathy. You've heard a great deal of evidence in this case, and this instruction cuts both ways. You heard a testimony on the first day of the penalty phase from the victim's family, from Alex's friends, about him, and it was very emotional testimony. It was very, very difficult to hear. It was heart-wrenching. And you heard testimony from the defense in mitigation of some terrible things that have happened to Bessman Okafor, things that very, very appropriately would make you feel sympathy for the child that he was. All of those things have to be set aside in your mind and in your hearts. You have to take all that sympathy that you felt for the victim's family and whatever sympathy you feel for the child that he was, and set that aside. Sympathy is not the basis of your decision here. Your decision must be based on a reasoned moral judgment, guided by the principles that the judge has given you. And I know from the dedication that I've seen in these last 3.5 weeks that you will do that. So, let's go to the process. The first question that you as jurors must address is whether the state has proven one or more aggravating circumstances. Obviously, as we said all along, if the state failed to prove any aggravating circumstance, your verdict would have to be life. In this case, that is not, I believe, even a reasonable question. In this case, it is beyond any question that the state has proven one or more aggravating circumstances. Let's just go through them for a moment. The first aggravating circumstance you will be instructed on will be the following. The defendant was previously convicted of a felony involving the use or threat of violence to a person. The judge will instruct you that the crimes of attempted murder in the first degree, and again, this refers to your own verdicts, finding the defendant guilty for attempted first-degree murder of Brianna and Remington Campos. Robbery, which refers to this document, State's Exhibit 67. This is the official court documents called a judgment and sentence, finding wherein the defendant was found guilty of multiple counts of robbery involving the home invasion from May. He had been tried on that back earlier in the year, and the dates are all in here, was found guilty and convicted. He was sentenced to life imprisonment. That is a sentence he is presently serving for the crimes committed in May. The judge will go on to include the crime of aggravated assault and tell you that all three of these are felonies involving use or threat of violence to another person. And the documents that you will see, and again, these will go back with you if you care to read them more thoroughly. State's Exhibit 66 is a document, again, a judgment and sentence, an official court document, in which the defendant was found guilty of aggravated assault with a firearm back in 2005 at, I think, approximately age 20. Those are all aggravating circumstances. You will give them the weight that you feel they deserve, and we'll discuss that shortly. The next aggravating circumstance that is submitted for your consideration is that the capital felony, that is the murder of Alex Zaldivar, was committed while the defendant was engaged in the commission of any burglary. And again, the jury's verdict has already found that proven beyond a reasonable doubt. That is an aggravating circumstance that you consider. The next two circumstances that we're going to discuss, in essence, are two ways of looking at the same thing. So I'll talk about them sort of together. And again, these are circumstances designated by statute by the legislature. So we give them to you exactly as the legislature gave them to us. It is the capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody, and the capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of the law. These both revolve around the reason that Alex was shot. And the reason Alex was shot, as established in the guilt phase of this case, is that on that September morning, Bessman Okafor was facing a trial for crimes he had committed against 4 absolutely innocent citizens. And that Bessman Okafor decided that he could not let them show up in court because he knew that if they did and he were convicted, he would go to prison for the rest of his life. And you'll see from the paperwork it's referred to as a prison releasee reoffender. On that September morning, Bessman Okafor decided that his life was more important than the lives of Alex Zaldivar, Brianna Campos, and Remington Campos. These people were shot. And Alex Zaldivar is dead because they had the audacity testify against Bessman Okafor. They had the gall to say that he should be held responsible for a crime that he committed, and that he could not allow. He murdered Alex Zaldivar to avoid lawful arrest or effect an escape from custody. He didn't want to go back to jail. And he thought, they're all dead. And he was right. He was right. If he had succeeded, he would have gone free on that case. In addition to an attempt to prevent a lawful arrest or escape from custody, he did it to disrupt or hinder the lawful exercise of any governmental function or the enforcement of the law. Same reason. And again, the court will instruct you later that though those two are separate in the statute, since they involve the same underlying fact, you actually sort of count them as one. You don't weigh them twice. That aggravating circumstance is proven beyond any reasonable doubt. The next is the capital felony was especially heinous, atrocious, and cruel. In one respect, you could say that any murder is heinous, or any murder is cruel. But the words used in this mean something more than that. The judge will tell you that the term heinous means extremely wicked and shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. And that pain can be either physical or mental pain. The court will tell you the kind of crime intended to be included as heinous, atrocious, or cruel is one accompanied by additional acts that show the crime was conscienceless or pitiless and was unnecessarily torturous to the victim. There are many ways to commit murder. Many are quick. But in this case, the defendant chose another way. Remember, in this case, the defendant and his cohorts took these young people in the middle of the night, woke them up from a sound sleep at 5 o'clock in the morning, the day before the trial was to go, herded them in to the living room. Didn't just shoot them where they sat. No, that wasn't good. Instead, what he did was he took the crime he had committed in May and he replicated it. Because he wanted them to know. He wanted them to know what this was about. He wanted them to regret in the last moments of their life that they dared testify against him. But he went beyond that. He didn't just replicate the crime. He made sure that they knew. Who's the naked guy? Where are the other two? You see, he wanted them to make sure that they knew. This wasn't just random. He wanted them in those last moments of their life to think, oh my God, he's back. And if that weren't enough, just to make it absolutely clear to them what was about to happen, he said, somebody's going to die tonight. He wanted them to know that their lives were about to end. It wasn't just about eliminating them. That would have been simpler. He wanted them to know that they can't do that to him. And we know from the testimony of Brianne, in her amazing sweetness and innocence, even up to the moment that she's shot, she still tries to believe that these people wouldn't deliberately do it. Remember, she said even after she was shot, she thought it was an accident. I mean, she's so sweet and naive that even up to that moment, she wanted to give them the benefit of the doubt. But Remington It's more realistic. Remington knew that when he heard the words, "Someone's going to die tonight," that it was going to be him. Told you how he thought about his 2-year-old son. We don't know what Alex thought. But what we do know from Remington's testimony is that Alex knew it was coming. Remember, he said, "I was laying there on the floor. I was looking at Alex's face, and he was looking straight down. And after the first shot, all I heard was, like he was getting ready." Alex Zaldivar, in those last moments, knew that whatever thought was in his head was the last one he would ever have. Whatever he was looking at would be the last thing he ever saw. Whatever he was feeling, that floor against his nose is the last thing he'd ever feel. And the panic that the evidence would indicate that he felt is beyond imagination. To have put any human being through that type of death is outrageously wicked and vile. Extremely wicked and shockingly evil. And is heinous, atrocious, and cruel. The last aggravator we'll discuss is that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or a prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. This is the same definition you heard during the guilt phase of premeditation. The court will go on to say, however, in order for this aggravating circumstance to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral legal justification is any claim of justification or excuse. There's none here. Remember the evidence from the guilt phase. I would submit to the evidence shows the defendant started thinking about this weeks before the trial. Remember, there were text messages going back and forth about getting a gun and about the witnesses showing up at trial. And I believe that was a couple of weeks before the murder. Those were, I believe, with his brother. Thing about the clip, and then there's references in the same conversation about the witnesses showing up. So I would submit the evidence shows that this started weeks before. But clearly, the day before this murder was when the defendant began to seriously plan. He recruited a crew of 4 people to help him complete this crime. 2 of them testified in the guilt phase of this case. He recruited lookouts, and he recruited muscle, and he got guns. He got latex gloves. They had a plan. He assigned the lookouts, told them where to go and what to do. He got a phone from, I believe, Mr. Wallace, and gave it to Mr. Cicerone, because Mr. Cicerone forgot his phone. Lookout needs a phone. He arranged everything perfectly. 3 cars, 1 at one location, 1 closer. 3rd car goes to the house. 3 people go in. Go in through the front door. Like clockwork. Each one takes a room. Boom, boom, boom. Within a few seconds, all 3 of them are down on the floor. After that, they ransacked the place to make it look like it was a burglary. And then Bessman Okafor puts on a latex glove. Remember, he had looked online about how to wash off gunshot residue. So in order to prevent having it at all in your hands, put on a latex glove. They heard it snap. And then he walked up and stood over Brianna Campos and fired a bullet into her head. Turned to Alex Zaldivar, fired one into his head. We don't know if he fired the second shot then or after Remington. And then he walked over to Remington Campos, a living, breathing human being who hadn't done anything to him, who wasn't even there, who was completely innocent, who was just lying there, naked on the floor, and he took that gun and he pulled the trigger for the 4th time and put a bullet in his head. And then he walked out. He was done. His cold, calculated, and premeditated plan had worked. The only problem was, apparently the Campos genes have thick skulls, because by a miracle, they survived. They shouldn't have survived. A .38 caliber slug going through hitting your skull is supposed to go through. But how did they survive? Who protected them? How did it happen? We don't know. This crime was cold, calculated, and horribly, horribly. So the next question then becomes, since the state has proven these multiple aggravating circumstances beyond a reasonable doubt, are those aggravating circumstances sufficient to justify the penalty of death? And I submit that in that process you have to apply weight to them. You have to apply significance to these aggravating circumstances. And I would submit to you that in the context of a capital murder case, it is hard to imagine a more aggravated case for someone who is facing trial for a crime that they committed to premeditatedly plan to go out, break into their victim's home, and execute them without mercy or thought, and to torture them mentally in the process, to go to the lengths I've described, to torture them. These aggravating circumstances are entitled to an immense amount of weight. Let's talk about them individually. The first one is the priors. The first prior is for aggravated assault with a firearm from 2005. This is threatening someone with a firearm, which is a very serious crime. But if this were all there was, if this were the only prior that we had, I would submit to you it would be entitled to some, but not a great deal of weight. It's a serious crime in the broader scheme of things, but it standing alone is not that significant. But unfortunately, this is not standing alone. What you have instead is this, which is his conviction for the home invasion in May. I would submit to you this is entitled to immense weight in your considerations because it is the reason that he killed them. He is presently serving a life sentence for this case, and that is something that you have nothing to do with. And I would submit to you that this is entitled to an incredible amount of weight because, again, this is the reason he did it. Add to that his attempt to murder Brianna and Remington Campos. Those are priors. You must give them weight. And I would submit to you that the total weight of all these priors is immense. It is significant. It is incredibly significant in this case. And you should give it a great deal of weight. The capital felony was committed while the defendant was engaged in the commission of burglary. Again, that is not an unusual circumstance in murder cases. Murders often happen during burglary, sometimes by accident, sometimes on purpose. I would submit to you that that is entitled to some weight in your consideration, but that compared to the others, it is relatively minimal. The capital felony, the next two, about avoiding arrest or hindering lawful exercise, are, I think, entitled to immense weight as well. Because there can be nothing more evil than the deliberate murder of a witness. There can be nothing more aggravating. There can be nothing that should be given greater weight in this kind of determination than the fact that you deliberately go out and murder someone who's going to testify against you. Our legal system simply cannot survive unless witnesses have some level of security.
Excuse me.
It's an improper argument.
Sustained. Sustained.
Ask that the jury, the court instruct the jury.
Jury will disregard the last comment.
You must give weight to that aggravating circumstance, and in the context of this case is entitled to an enormous amount of weight. And again, those two circumstances are considered. They involve the same underlying facts. The heinous, atrocious, and cruel manner in which Mr. Okafor chose to execute Alex Zaldivar, I've gone through it already. I don't really want to have to go through it again, is, in the words of this, shockingly evil. A shockingly outrageous, evil, cowardly act, and is entitled to an immense amount of weight. The calculation, the coldness, the planning of this crime, again, is proven and is entitled to an immense amount of weight. In the last analysis, ladies and gentlemen, I would submit to you that this evidence not only justifies the penalty of death, it virtually demands. It's hard to imagine a more aggravated crime than this one. So the only issue you have to decide is it sufficient to justify the death penalty? I think it is beyond argument that it is sufficient to justify the death penalty. The next question you look at in the analytical framework of the death penalty is, well, what mitigation has been provided? And what weight do I assign to it? I'm going to talk about a couple of different areas of mitigation provided. The first is the evidence that was provided to you about the defendant's Nigerian relatives. You know, in speaking with some of you in voir dire, I used an example of, defendant got a track ribbon in 5th grade. That may be true, but what does it mean? And I would just submit to you that what level of prominence the defendant's grandfather had in Nigeria. Now remember, the grandfather is someone he's never met, never sought out, for all we know, didn't know existed until his aunt called him during the pendency of all this case. That what his grandfather's status is or is not in Nigeria is like the 5th grade track ribbon. It is, I would submit to you, in the context of this important decision, something that is entitled to little or no weight. Because who cares who his grandfather was? I mean, he doesn't, the sins of the father aren't visited on the son, but the accomplishments of the grandfather are not, visited on the son either. So what difference does it really make? Whether his grandfather was a high chief or a sewer worker, what difference does it make in that case? And I would just submit that virtually all of that information, it falls into that category. It's up to you to decide that. If you feel that it deserves some weight, then that is your choice. But in the context of something as important as this, I would just submit that that is entitled to virtually no weight. You've heard a lot of information about the defendant's background, about his father. You've heard a lot about his father, someone that he didn't know very well, but apparently was impactful in the early part of his life and whose death did hurt him as a child, as it absolutely is understandable that it would. And again, that may be entitled to some weight. I would submit to you that in the context of this process, things that make you understand the defendant better in the context of this crime deserve weight. Because if it lets you understand, in other words, if it lets you understand that this act that appeared to be so unimaginably evil has some explanation or understanding, that those are the things that are entitled to the greatest amount of weight, because it makes you...
You may.
Make sure my...
Please proceed.
As I was saying, those matters which give you insight into what appear to be these evil acts, I was going to give you great weight.
Did you turn your microphone back on?
Oh, I'm sorry. Okay. In this case, I believe the defense has witnesses have essentially conceded that this information that you were given really did not relate to the crime itself. There is no attempt to use this information to establish some mental disorder or some personality disorder that might, you know.
Legal basis?
Counsel is implying a mistake of the law.
Approach. Please proceed. Make sure the microphone's on.
As I was saying, the last witness, conceded that he's not claiming that Mr. Okafor suffers from any mental disorder or personality disorder or anything of that sort.
Objection, arguing lack of mitigation.
Overruled.
So, the challenge then becomes, how do you weigh this information? We know from the jury instructions that it's not about sympathy. It's not about that the things that happened to Mr. Okafor make you feel sorry for the child that he was. And again, the information that you've been given essentially stopped at about age 14. You have heard precious little information about the man that he became. It sort of stops at age 14 with the molestation, and then you hear very little else in this mitigation case about that. So, if you cannot give weight to the mitigation based on mere sympathy, and the mitigation doesn't help you understand the act, then the challenge for you is, what weight should it be given? You know, what significance does it have? I mean, everyone has things in their childhood, some better, some worse. I would submit to you that Dr. Gold has overstated the level of horror of Mr. Okafor's childhood as compared to the general public. He made it sound like his was the most horrendous childhood ever. And part of my role in cross-examining witnesses is simply to try to bring out the bigger picture. Catalina Ruffin may not have been a good mother, but she was a hard-working mother, and she was there. She wasn't a crack addict, she wasn't an alcoholic. So as flawed as she may have been, and as ill-equipped as she may have been to be a parent, and whatever else you may say about her, she was there. She still is. The stepfather, Trevor Sinclair, as she said, we fought. And that should not happen in front of children. But the evidence that he was an alcoholic appears to have been almost completely refuted at this point. You know that Trenton, Mr. Okafor's brother, initially told Dr. Gold, nope, he doesn't have a problem, and then came in here, after very appropriately speaking to the defense team, and added additional information and said, oh yeah, he had a terrible drinking problem. And when I pointed out to him, well, that's not what you told Dr. Gold, in January he said, well, drinking didn't mean beer, which I submit to you is that the point is that people are made to seem evil. And I would submit to you that part of the purpose is to sap some of the evil away from the defendant, if we can point to other people that are evil in his life. But as flawed as they may all be, I would submit to you that Mr. Okafor's life was not what it should have been. Dr. Gold told you that he, based upon what he saw, and some of Dr. Gold's, I think, I would submit to you, stretched a little bit of the facts to make it fit these 10 criteria. The one example is, one of the criteria was a family member was incarcerated, and I would submit to you that means someone went to prison, but Dr. Gold said, well, his mom went to jail for a day or so, so that's a risk factor. Whether that's accurate or not is subject to question. One of the risk factors was an alcoholic parent, and again, it's, originally it sounded like they were trying to say that Trevor Sinclair was an alcoholic, and then Dr. Gold, oh, Sinclair, the guy before him. Well, those are all important things. They're important things in understanding Mr. Okafor's life and what happened to him. He was victimized at age 14 by a 33-year-old man. And you have the police report here, and I advise you to go back, read it over. It contains pretty much the facts of what happened. It also contains Mr. Okafor's statement about his interpretation of what was going on. It goes into the fact that this was an event that happened over a number of days, that there was sort of initial touching that moved on to other things, and you can assess what actually happened and the impact. The evidence that this impacted Mr. Okafor in a negative way at age 14 is undisputable. One can only imagine the embarrassment and humiliation that he must have felt at age 14 for this to have occurred to him. And that is true. And that is truly tragic. No child should ever go through that. But again, the weight you assign to that can't just be based on sympathy. It can't just be based on saying, wow, it's really bad that this happened to him. It's tragic. It has to come from somewhere else. It has to come from some other way that this matters in this case. And that's up to you to decide. And counsel will argue that to you in a little bit. Evidence of how he was punished as a child. People often do what they were raised to do. And Catalina Ruffin's parenting style was not something that today is acceptable, or maybe even was years and years ago. But again, you have to put it in the context of her as a mother as a whole, and then ask, what does that have to do with this case? And give it what weight you think it deserves. The testimony of Dr. Taylor, who was the educational psychologist, I think is interesting because it was presented to you to show that Mr. Okafor has a learning disability, which he may in fact have. What is unusual about it is that it was based on such limited information. Dr. Taylor told you that there are tests that can be given to determine the present functioning of Mr. Okafor, to determine does he continue to have a reading disability, has it been improved, etc. And what's interesting about it is that he isolated some comments in those records about learning disabilities, and then without even having attempted to talk to any of the educators who worked with this child, as difficult as he was back then, he pronounced them deficient. He pronounced them deficient not because he had spoken to them, not because he'd researched them, not because he found out what they actually did. He never attempted to determine from these educators, and these are hardworking people trying to educate kids, what did they do? How much of his problems in school were related to a learning disability or some underlying conduct disorder? When on cross-examination I got him to go through those records and to repeat for you what these educators were actually saying about Mr. Okafor, it presents a very different picture. Even he said some acting out is to be expected with a child with a learning disability. But even he said this level of aggressiveness is not just explainable by what went on. Maybe it's explainable by what happened at home, but we don't really know. The point is that the value of cross-examination is to give the complete picture. And the complete picture of Mr. Okafor's childhood is a complex one. I would submit to you that the defense has not really given you answers. It's given you snippets and snapshots and bits. But it doesn't put together a whole as to what this childhood meant. Defense is going to get up here and argue to you what he believes this mitigation means. And it's up to you to decide ultimately what weight you give it. I would just submit to you it's difficult to find a framework to give it weight, since you can't use sympathy and you can't use, it's not related to the crime. So, should someone's sentence really be different because they were corporally punished by their mother or because they were molested? That's up to you. It's completely up to you to decide. One other thing that the defense has placed into evidence that really hasn't been discussed that much, we talked in the guilt phase and about the co-defendants in this case, Emmanuel Wallace and Donnell Godfrey. Both Mr. Wallace and Mr. Godfrey were tried. I believe Brianna related testifying in both those cases. They were both convicted by juries. They both received sentences of life in prison. They did not receive death penalty. Now, if from the evidence you believe that these two individuals are equal in culpability and responsibility with Mr. Okafor, that may in fact be a mitigating circumstance. But in this case, I submit that that's not the case. The evidence in this case makes a few very important distinctions between Mr. Wallace and Mr. Godfrey, by the way, who are both serving life without possibility of parole, and Bessman Okafor. The biggest one is that they didn't kill anybody. They didn't kill anybody. We don't know that they knew anyone was going to be killed. And the death penalty is reserved for those who kill or have an intention to kill. In this case, it's guesswork. The other most important thing is they had nothing to gain. They had nothing to gain from the death of these two individuals, only Bessman Okafor did. And as horrible as they are, and as deserving as they are to never breathe free air again, their cases are not as aggravated as Bessman Okafor. And that's why they were treated differently. You may give that whatever weight you think it deserves in mitigation, but I would submit to you that it deserves very little. Yeah, I haven't tried to go through every single bit of testimony, every photograph that you've given in this case. You'll have a chance to do that when you go back. The last question is, you look at the mitigation. You determine what is proven what is proven to be true. And there are some disputed issues here. For instance, whether Mr. Sinclair is an alcoholic or not. That's a disputed issue. You decide what you think, and you give it what weight you think it deserves. But in the end, your last and final duty here is to compare the weight that you have assigned to the aggravating circumstances in this case, which I submit to you is immense, against the weight that you give the mitigating circumstances in this case. And again, I would submit based upon not being able to use sympathy and its lack of relationship to the conduct, that the weight is not great. And once you have done that, it is then your duty to recommend to this court what the sentence should be. Now, the defense will point out to you, which is stated in the instruction, that even if the aggravating circumstances far outweigh any mitigation presented, it's not even close, that you are still not obligated to recommend death, and that's absolutely true. You can choose to abandon that weighing process and to give him life just because you feel like it. But I'm going to ask you not to do that. I'm going to ask you to use the process that the law provides, because this decision is too important to be left to our individual whim and caprice. Equal justice under the law is best served when you allow yourself to be guided by its dictates. And I would submit to you that if you do that, that if you apply your reasoned moral judgment to the facts and the law in this case, that each and every one of you, deep in your hearts, will come to the inevitable and undeniable conclusion that the death penalty is justice in this case, and in fact is the only just recommendation. In September of 2012, Bessman Okafor decided that Alex Zaldivar should die by the hand of man, that he would not be allowed to live past the age of 19, that he would not be allowed to grow old and die of natural causes, that he would die by the hand of man. And ladies and gentlemen, based upon the aggravating circumstances in this case, Mr. Okafor deserves the same fate, to die by the hand of man. And that is what I ask you to recommend.
Thank you. Ladies and gentlemen, I'm going to go ahead and give you a short break in this matter, about 15 minutes. Once again, please do not discuss this case. Please keep an open mind. The defense is going to have an opportunity to do their closing in this matter. So if you would go back about 15 minutes, leave your pads on the chairs.
All right, great, thank you.
We'll be in recess for 15 minutes. Mr. Doctor, if you need anything set up.
I was going to go sell it. I don't.
Okay.
Thanks. You guys want to take a break? He's going to take an hour post.
Where's the? Yeah. Let me show you something. I'm up this morning, and it's basically what I'm going to say, but maybe 4 or 5 because of my rejection.